right?
Yes, I have accused myself of being the judge in that court who is all too free on reinstatement. Having said that, and with my issue in my reasoning in mind that employment in Kenya is like a matter of life or death. Whenever you can get back to work, please get back to work. Two, the immediate date. In this case, we have established a case of unlawful termination of employment. That is ugly enough. You've been out of work for so long. Another very ugly situation. You've gotten judgment in your favor. The practicability of, giving you time to return to work, to me, would not make a lot of sense. Because the employer is there, he has offended you, he has transgressed your rights, he has made you suffer for no good reason. What is this so critical situation, which would be worse than what you have suffered, that would require that we give you 2 months to resume work, etc., etc. I have never thought that it is impractical. I've always thought that it is immediate, and that is what I have done in all my cases of reinstatement. I have never considered that I am being offensive to the employer. If the employer finds that he is not ready or etc., etc., I have returned your employee. Deal with the situation. That is a domestic matter. The judge has done his work. And to me, that makes a lot of sense. If I am faulted by other quarters, I am agreeable.
Then in the same decision, you went ahead and said the respondent be and is hereby ordered to meet and pay the respondent's salaries and allowances owing but unpaid during his suspension, which is all right. So basically you're compensating the petitioner for the time that you found that the termination was unlawful. So you are reinstating them, kind of like putting them back to the same position they were before termination.
Yes,
but which is fine. But my problem again now, which I couldn't understand, of course I'm not the judge here, just need to understand your reasoning. You go ahead again and say you're also awarding 6 months salary as compensation for unlawful termination of employment. So you are not only giving the salary during that time, plus all the allowances, you are reinstating them to that position, but you're also adding another burden of another compensation on top of the compensation you've already awarded. So, I mean, I'm not really getting, what is the reasoning behind that and the fairness in it, the justice in the matter. Could you kindly just expound on the jurisprudence behind that?
The issue of a 12 months compensation, which must not necessarily be 12 months. 12 months is the limit. You could do a month, you could do half a month, you could do 3, 4, 5, 6, etc., etc. And Section 49, 1C of the Employment Act is not in entirety the total compensation available to a case of unlawful termination of employment. The judge has the discretion to look for other remedies which are available and which have been prayed for to offer. And this will depend on the circumstances of the case. The judge exercises his discretion depending on the circumstances of the case. By the time you do the matter and finalize, you've gotten the gist of the matter, you've gotten the involvement of the parties, etc., etc. That is what dictates what you offer the aggrieved party. And in the circumstances of that case, we are compensating unlawful termination differently from any other issues of compensation that may have arisen in the circumstances.
Yeah, that's all right.
And that is allowed.
Yeah, Judge, but it's only that, again, the discretion must be exercised, should not be exercised whimsically. And again, you see, you already compensate the person. But I don't want to make it an argument, I just need to understand your jurisprudence. But now, you've reinstated the person, which is fine. You've said they be paid all their salaries and allowances, which again is fine. I don't have an issue with that. But now again you are saying a permanent injunction be and is hereby issued restraining the respondents from commencing any process towards replacement of or replacing the petitioner in the position of Deputy Registrar Administration. Now, if they are already back in the position and you've compensated them, but you are saying that there should, basically what you essentially you are saying is that there should not be any process towards replacement. So if this person misbehaves again, you know, it means then that the hands of the employer are tied. They can never start any process. So again, what is the reasoning around that?
Thank you, good counsel and commissioner. I relied on the historicity of that matter, the background and the data available, the evidence in the matter. What did I hear? What did I know? etc, etc. The environment was so hostile that we had to safeguard the position of the employee when he goes back to work for various reasons which are very clear, that that was a very hostile affair. And two, the issues which they were fighting were not issues which were industrial. All evidence will tell you that it is personal. So when it is personal and you can see it so clearly, you may not be able to declare it or say it, etc. What you do is issue as much safeguards as are possible to the employee. The employee and the employer are not equal. This is an interplay of labor and capital. Capital is always superior. So you safeguard you safeguard labor depending on the circumstances. You safeguard the capital, or you remedy their situation depending on the circumstances. In that, under those circumstances, and knowing the matter the way I did, I was convinced that that gentleman required, the claimant required security in his employment.
Yeah, but you see, Honorable Judge, when you are telling an employer that he should never touch this person for as long as they're an employee again.
Oh, thank you.
Basically, you're tying. But let's move to the next.
I could answer that very briefly.
Yeah, please go ahead, Judge.
If you choose.
Yeah, please go ahead, Honorable Judge.
That was not permanent in that sense. In fact, when he resumed employment on day 3, if he missed, they would restart the process. That was supposed to deal with that situation, the situation we were adjudicating, not anymore.
Yeah, but you see, the way your order was framed had the opposite effect. That's the problem I have, and that's why because I'm asking you jurisprudential questions, because you'll be the leader of jurisprudence in the institution. So that's why I'm asking that question. But now, let's test your decisions, because I had to again now do a bit of research, because this matter of Professor Misia Manguti Kadenyi, the one you asked by my honorable colleague. Now I went ahead and actually noted that it's a matter that was a subject now of the Court of Appeal. It didn't end just with your court. And now what I noted is that, for instance, the award that you had given in this Professor Kadenyi case, apparently what you had done is that you had awarded compensation, you had picked salary, which you awarded against the employer, which was not supported by any evidence at all. The evidence was based on the evidence that had been given to you was showing a monthly salary of 333,640, but you picked instead 658,112. In fact, the court said, we have carefully gone through the judgment of the trial court, and there's no indication at all where the monthly salary of Kenya shilling 658,112 is taken from. There is therefore merit in the submission by the appellants that this figure is unsupported by the evidence, and we therefore set aside the learned judge's finding the monthly salary of 658,112 and substitute therefore with a monthly salary of Kenya shillings 333, 640. So you can see a problem whereby you are probably making a decision based on other considerations, probably emotions, and I can see you keep, in all these decisions, you keep quoting your personal case against TSC, which again, in this case, you are being accused even by the appellant, saying that you seem to be relying more on your personal experience with the National Teacher Service Commission, and there seems to be anger and, which is because of probably you are feeling that you are mistreated, you are now transferring it when you are now deciding decisions. So, I mean, wouldn't you consider this to be a serious indictment even by the Court of Appeal regarding how you are making decisions of a mandatory nature against employers and supported by evidence? I don't know what would be your consideration to that, Honorable Judge.
On the first issue, the issue of the amount which was multiplied as a compensatory figure, the 629. Section 49(1)(c) of the Employment Act covers that. Section 49(1)(c) talks about gross salary, not net salary. The employment law does not know net salary, because when we are compensating you for unlawful termination of employment, we go by the law, and the law provides that we use the gross salary. So what a judge on finding of a situation of unlawful termination of employment would look for on the pleadings is all the itemization of dues. I was paid 4,000 shillings as a basic salary. I was paid 1,000 shillings as a house allowance. I was paid 500 shillings for transport allowance. That is what you add up, and that is what I did to get to a figure of 629, including the car allowance, which was, if I remember right, 129,000 shillings. So you add all that, you must accumulate all that to get what we call the gross salary. And that is what now, in your discretion, 1 month, 2 months, 12 months, 10, blah, blah, etc., etc., you use as a multiplier effect to get the figure. The Court of Appeal, we may not be able to correlate it. It binds us insofar as that matter is concerned.
Yeah.
But going back to, to ourselves, we would always want to ask ourselves, which is the earlier? Is it the Court of Appeal and its findings in the professor's matter, or Kisirkoi's matter, or the Employment Act? A big question.
Yeah, but
I have answered your questions. If I haven't, I could
well,
continue.
The principles of stare decisis bind you. This is the Court of Appeal. Now, again, then, my lord, again, you see, in Samson Ole Kisirko, you made that order that the employee reports the following day. And what I noted is that in, again, Professor Misia Kadenyi's case, you did the same thing. Ordered that, report tomorrow. So in the Court of Appeal, this is what they had to say about that issue. We wish to state that in instances where the court is satisfied that an order of reinstatement is deserved, it is not prudent to direct that a claimant reports back to office within a day from the date of a court's decision. Such a drastic order is likely to present considerable implementation challenges to an employer. In our view, a reasonable period, depending on the circumstances of each case, ought to be given for the reinstatement to be effected. So you can see when the Court of Appeal is saying that is too drastic, there has to be reasonableness. And you see, the reason why I'm asking this is because you'll be our Chief Justice if you become one. Now the issue of reasonableness now starts arising in your decision-making process. I don't know whether that makes you change your mind regarding those kind of drastic orders that you keep making, that, I'm issuing an order, I want it implemented immediately without considering the challenges that would arise from the implementation. Not just in the decisions, but even in your day-to-day decisions that you could make here as our Chief Justice.
Well, thank you, good Commissioner. We are open to learning. That is one, first and foremost. But like I said earlier, that is what I have practiced throughout my career, 10 to 9 years in that court. nobody has raised an issue on that in the past. The matter you are referring to was not an ordinary matter. There were other, side issues relating to the matter. As the Chief Justice, we would not like to do anything which hurts anybody, even as judges of the employment court. I would never have imagined that when I tell somebody to go back to work the following day, there would be an issue. Because employment is contracted. The employer could go back the following day and is given a week's leave. In any event, he's been away for so long. The employer could go back the following day, and then another different arrangement is made. All those factors come into my mind when I said that. The agency I created not because I want to make it impossible for anybody, not because I want to punish anybody. I want to, it's an indication of urgency. It's an indication of seriousness insofar as labor relations is concerned at the workplace. I am telling everybody that good enough, you are secure when you harmonize your relationship with your employees. When you don't do that and you deal A, B, C, and D, what we shall do is we shall tell them to return. And not because we want to be offensive, but because it is their right. But primarily, I think the whole matter is open to the employer and the employee to deal with that aspect. And if we don't have impossible situations, because we are human, when it becomes an impossible situation, there's no employee who takes charge of an industry. So if he's told by the employer now, you can come back in 2 weeks, 3 weeks, etc., that would be okay. That would be good practice. You will not insist that it just sticks there and stays there and gets the fruits of immediate reinstatement.
Okay, Honorable Judge, just 2 more points on that decision.
Please.
That we move to something else.
Yeah.
Again, you see the same decision of a prof. Now, the evidence was very clear that the position of Deputy Vice Chancellor, Academic Research and Student Affairs had already been abolished. But that notwithstanding, you still went ahead and said that I'm reinstating you to this position. Now, again, I'm not able to understand why you would insist on reinstating somebody to a position that no longer exists. And in fact, to that effect, the Court of Appeal again said, considering that the position to which the respondent had been appointed had been abolished, we think that it was not an appropriate case to order reinstatement. Balancing the interests of the parties tilted in favor of not ordering the reinstatement, we therefore allow this ground of appeal. So why would they take for the Court of Appeal to be the one now to see that it doesn't make any practical sense at all to order a reinstatement of somebody to a position that does not exist? So again, I'm not understanding the reasoning, around that.
If you get to the background of the matter, you appreciate that that was not a matter industrial relations. The issue was not industrial relations. The issue was personality. You versus somebody else. The Vice Chancellor versus her deputy, etc. And it was not even more personal. It was strictly a personal matter.
Yeah, but
so when it comes to me, and I take that evidence, you say that the position has been abolished. That is your evidence. The other one says that no, the position is not abolished, and if it is, it was not done in good faith. So where does that leave us? When we get a situation like that, when we have over-reinstatement in that kind of circumstances, we have the most obvious choice. That one of getting back to a position similar to, getting reinstated to a position similar to what you have. But looking at the historicis of that matter, I thought that we should not encourage personalization of industrial relations, of employment issues or employment contracts. later return to that office in the same position, the balance belongs to them. The Court of Appeal things are
agree with you,
different.
but you have to always remember that you have to remain a judge based on the evidence, the facts, the law. And you see, this is a case where there was an opportunity for either reinstating to that position or the position of the professor to continue teaching. You reinstated both. The first one was okay, even the Court of Appeal agreed that the one of the professor, that's fine. But this other position, because teaching is always teaching, so you can't say you've abolished teaching, so that's fine. But you reinstate someone to a position that does not exist. I mean, don't you think then that you're putting, the employer in a situation that they can't actually be able to comply, making orders that are in vain,
I am saying that there was evidence wholly on the situation on the ground. There was evidence to the extent that this matter was not so much employment or industrial relations. It was a matter which was, personal. The Vice Chancellor and the Deputy Vice Chancellor.
Okay.
ETC, ETC.
Yeah.
And that is why I dealt with it that way.
All right, we'll leave it at that.
The Court of Appeal has come its own style.
Yeah.
It has taught us one or two things.
Yeah.
I had other options, which I chose not to take for various reasons. I get it.
Yeah. Then this issue of keeping on quoting your case was also submitted on, extensively. It was found to be, whereas it's a matter of your choice, but not tidy, as was also observed in a passing. But now let's leave the cases now. Let's discuss now you as an individual, so that if you come here with us, be with us, we can see whether you can be able to do the job. Now, you asked about the question of collegiality in the Supreme Court, where it would be now the president of the Supreme Court. I would want to understand, like, for instance, if the disagreement among the judges there, and you be now the president, and I'm talking about disagreement, not about personal disagreements. I'm talking about disagreements on decisions. Now, I would want to understand, again, not in so many words, how you'd want to, which way you'd want to go in terms of managing it. And I'm asking this because, not because of our Supreme Court, because I took interest in some matter in the Supreme Court of US, small versus Memphis, light gas and water, that is the case, where the Supreme Court declined to take over to take an appeal which sought to review a famous case of 1977, which would have reversed a precedent that had been established in the US. But two of the judges disagreed, with the refusal by the other judges, specifically Neil Gorsuch and Samuel Alito. And they actually went public, wrote, a decision totally disagreeing with their colleagues and all that, and went public. And of course, the other judges were quite unhappy with that kind of with that line of action. How would you deal with a situation like that, and what would be your preference in managing a situation like that?
This is an experience I may not have. It's an experience I am going into immediately when I become a Chief Justice of the Republic of Kenya. So how do you manage that? At our induction course many years ago at the JSC, we were taught elaborately the subject of collegiality by one of the commissioners here, the Honorable Attorney General of the Republic of Kenya. And this simply means creating brotherhood. Judges are limited in decision making. I mean, there's independence in the decision making. But my understanding of collective decisions, like the ones of the, big bench decisions, is that these are negotiated. There is a conference, there's a conferencing And after conferencing, they get it to level 1, maybe level 2, agree, and if there are any dissents, the dissents also take their place. So, in the circumstances of that kind of situation, however hard the matter is, the judges of the Supreme Court have a duty to deliver justice or to make determinations in all matters, regardless of the intensity or difficulty. We cannot just come out and resign and tell Kenya, no, this one is beyond ourselves. So you see to them.
Okay, so you'd agree with me that experience in managing, even a bench. You said you've never been in a situation whereby you've sat even with colleagues in one bench. I think that's what you said, that also is it's necessary to have that kind of experience, which probably you know.
When we get to the Court of Appeals, to the Supreme Court, I'll be one among its equals.
All right.
There are many judges there who have vast experience in these matters, vast experience at the Court of Appeals, vast experience at the High Court. So there's nothing we lack. It's just a question of teamwork. You can, get off the chair over the Supreme Court in a session where we are doing the conference and hand over to somebody else who takes charge and guides everybody and leads and teaches. In fact, a colloquium is an issue of teaching, exchanging ideas. Sorry, not a colloquium, but a conference. Is a teaching and exchanging and sharing differential, merging differential, etc., so that you are able to create a consensus. And that is where we are. The issue of being Chief Justice and Chairman is just peripheral. This is a team of equals. And we must always recognize that there are two types of seniority, insofar as the legal profession is concerned. The seniority based on the date of admission to the role of advocates, seniority based on the date of appointment as a judge, the date of entering that role. So those must be taken into account. But overall, knowledge, expertise, experience, goodness, cleverness, and what have you are not an issue of possession. They are an issue of knowledge. Knowledge is basically knowledge. You know or you don't.
My Lord, I was referring to the experience.
Honorable Judge, maybe you can be addressing the commissioner asking the question with respect. It's good to address the commissioner asking the question first.
I was referring to the experience. You see, the High Court judges, sometimes you find that a bench has been impaneled, so they manage that. Same thing also in the Court of Appeal, of course, the deal with benches, and Supreme Court also, they sit, and many of them. That's what I was referring to. But now, again, I'm wondering, you said that when you were asked one of the questions, I think it's when you were asked about leadership, and you said that you've not sat in any big office, and you actually talked about having risen up to, I think, senior state counsel, and then you referred to being a senior, I think, legal officer or something at the TSC, then you became a judge in industrial court. Now, so I'm wondering, if we give you again this position of the Chief Justice, which is quite senior, where you are responsible for for a lot of resources, a lot of issues, is an arm of government with many responsibilities. Now, I don't know what you do to convince me that the learning curve wouldn't be a challenge, because we can't take chances. It's a position. You see, there's a position that there's also very high expectations from Kenyans, the members of the public. Now, I'm just wondering, as the Judicial Service Commission, how would I, for instance, as a commissioner, account to Kenyans that I've given to my Lord, yet, the burden of proof on his part that he is equal to capacity, not based on what he's telling me that he'll do, but based on his past, that he can be able to prove that he's equal to the task. How would I be able to account to Kenyans? I'm asking this with tremendous respect, not to demean what you've done before, but I'm just saying responsibilities versus what you've done and the office. How do you convince me so that I can be able to give you marks with that in mind?
In the first parliament in 1963, when we got independence, most of our cabinet ministers were less than 30. They were politicians. We had not been, we had not ruled ourselves whatsoever, but we walked through. Mzee Jomo Kenyatta was a president. He has not been a president whatsoever. He was just an activist, a politician, a freedom fighter, but we walked through. What we are saying is that to gauge what I'm capable of doing as a Chief Justice, look at what I did in Sharia House in 1.5 years between 1985, 1st of August, and January 1987. Gauge that, look at it, etc. How did I relate? How did performance, etc. Whom did I lead? Whom didn't I lead? Because even when you get people from, people, you are